public comments at the end?
That's just how I know it's
Oh, okay. I don't care. Yeah, we'll just do it by your order here. The only thing is, I mean, we have hearings. We're not going to do any additional hearings.
Yeah, so it's basically, so we can
Just
get
the
the,
decisions,
yeah, I wasn't
right?
sure, I had left that open to, so,
Okay.
take the board.
New
wanted
evidence?
additional.
Discover new evidence?
Yeah, or, you know, if the board wanted additional argument,
Yeah, I have no further argument.
yeah.
Okay, I think we're going to be live here, guys. Okay, so I'm going to ask everybody to please turn on your mic. Make sure the green. Let's turn on Mr. Cohen's. You have yours on, Tiff?
Yeah.
Okay, so we are live. So we're going to call the Municipal Officers Electoral Board of the City of Berwyn to order. Roll call. Alderman, Mayor Lavero here, Chairman. Alderman Avila.
Present.
Public member, Mr. Cohen.
I'm present.
Okay. Neither attorney has anything more that they wish to state with respect to the objection and the motion for dismissal?
Nothing further, Mr. Mayor.
Nothing further, Mr. Mayor.
Okay, the way I understand this is because it's kind of the same issue, that the hearing on the motion to dismiss, the decision on that is going to apply obviously to the overall objection and complaint.
That is correct.
So basically, and I'll start it off, I've done a lot of research into this. I've done a lot of reading. I've done a lot of, I read the Rudd case actually in its entirety. The memo provided by the board attorney was also very thorough with respect to the case law at this point. I've read section 10.3. I've also read section 743. I will tell you that I don't put much stock in the township opinion of the last election. In fact, the township board, in my opinion, just made an erroneous mistake in a hearing they just had, which is against the law that's out there. Our predicament is that we don't have any precedent in this case. We don't have set case law pertaining to this type of situation. And argued both beautifully by both parties, it's very difficult to determine whether or not the sections that we talked about actually applies to a new political party or not. As I read the Rudd case, I definitely saw that there was plenty of dicta in there, not just the ones council brought out, that said it doesn't apply to a new political party. But again, it's dicta. We understand that it's not precedent. I also did a conflict with respect to the dual signing exclusion, and especially when we're talking about 10.3. It's difficult to determine what the intent of the legislature was when they passed 10.3, but it's very clear that they put independent candidate, independent candidate, independent candidate in every section but the one that council argued that should apply to a new political party. I don't know that I can accept that, however, because it would appear to me that had they meant it to apply, they would have made it specific like they did independent candidate everywhere else. Again, the dicta is not precedent, but it seems to bear out the argument that these sections do not apply to a new political party. Based on that, based on my reading of the memorandum from our board, based on my reading of the election code and the Rudd case, I'm going to sustain the motion to dismiss and find in favor of the candidate. Alderman Avila?
Yeah, I also read through a lot of this paperwork and feel basically the same way. There is no precedent for what we're experiencing here at this time. I know we're talking about this case, but if Alderman Ramirez had done the right thing at the first case by signing and notarizing those documents, we wouldn't even be here. Simple as that. So, based on all the findings, and both of you guys really did, attorneys did express your opinions thoroughly, which helped us make, the decision, so appreciate that. I think based on everything that we've seen and heard, I have to concur with the chair.
Public Chairman Cohen? Mr. Cohen?
Did we lose him?
Yes, I'm sorry, I had my mute off, so I wouldn't bother you there.
No problem, sir.
Thank you. Thank you, Mayor, I'm sorry. I also, like you, had trouble trying to figure this out and see what the intent of the legislature was. And I'd like to echo your points about thanking the board's attorney for the memorandum she prepared in her written analysis that helped me evaluate details in my decision and clarify my own analysis. Before explaining my analysis, I'd like to confirm a couple facts. Am I correct, there's no dispute between the parties that 25 is the minimum number of required signatures to be eligible to be placed on the ballot?
That is correct. However, that matter with respect to the original objection was withdrawn.
Okay. And did we, is there argument about whether the 68 total signatures, there are 68 total signatures for the candidate's new party?
There was an agreement that 4 of them were not valid. They weren't scratched out, so that I believe there's less than 68. How many were there, Counsel?
No, sir. The 68 excludes the 4
Okay.
that were stricken.
My mistake. Yes, there was 68, sir.
And then I looked at Exhibit A, and am I correct that there's no dispute that the number of individuals listed in Exhibit A who signed both documents is 48?
We did have, Mr. Cohn, it's Mike Dorff. We stipulated that 47 of the 48 were the same person, the same persons.
All right. Thank you, Mr. Dorff. In evaluating this matter, I did, like the mayor did, the chair, I looked at the 5 sections of the electoral code, 7-10, 7-43, 10-2, 10-3, and 10-4. And in this situation, the candidate, as we all know, filed 2 sets of signatures, and he filed the first set to run on the Democratic Party ballot in the primary election February 23, and then withdrew his candidacy and subsequently filed to run on a newly created party's ballot in the general election of April 6. And it appears that the people who signed the candidate's first set of petitions for the Democratic Party and the 47 of those later also signed the second set of petitions for the new party. So if all of those 47 were invalidated, the candidate would have fewer than, it seems, would have fewer than the minimum 25 signatures to get on the ballot. So here, the way I look at it, we have 2 filings by the candidate and 2 signatures by some of the signers. And I'm going to refer in shorthand to these 2 situations as dual filings, because the candidate filed 2 things, and dual signatures, where there were some people who signed both filings. So the posture of the litigation, as I see it, is that this is an issue of dual signatures, not dual filings. So I looked at 7-43, and that was cited during argument. And it says, a person who filed a statement of candidacy for a partisan office as a qualified primary voter of an established political party may not file a statement of candidacy as a candidate of a different established political party or as an independent candidate for a partisan office to be filled at the general election immediately following the general primary for which the person filed the statement. And I believe that 7-43 is not applicable because it relates to dual filing and not to the dual signature situation. Then I looked at section 10-3, which is cited in paragraph 6 of the objector's petition. That statute, 10.3, says each voter signing a nomination paper shall add to his signature his place of residence, and each voter may subscribe to one nomination for such office to be filled, and no more. Then I turn to the first sentence in section 10-3, which is intended to describe to what type of candidates 10.3 applies. And the first sentence there begins with these words: nomination of independent candidates, not candidates of any political party, for any office to be filled by the voters of the state at large. Because the General Assembly, in my opinion, intended 10.3 to apply to independent candidates, it does not apply to the new Progressive Party or to that party's candidate who was the respondent in this litigation. Then I looked at section 10.4, and that section says no person shall circulate or certify petitions for candidates of more than one political party. And the allegation in paragraph 6 of the objector's petition is that 48 or 47 individuals whose names were listed in Exhibit A were petition signers, not petition circulators. 10.4 says it applies to persons who circulate or certify petitions. Because it does not apply to petition signers, it is inapplicable in this situation, in my opinion. Notwithstanding this analysis, I continued to look to see whether there were any other indications that the General Assembly intended Section 10.4 to apply or not to this situation. The question previously addressed is, were each of the two sets of signatures filed for a political party? In other words, was one set of signatures filed for each of two political parties? And if there were two political parties, then the language just quoted could, at first glance, appear to disqualify the second set of signatures from those signers who signed both sets of petitions. And this could cause the candidate's number of valid signatures to fall below the minimum. And if I just may requote 10.2, it says, no person shall circulate or certify petitions for candidates of more than one political party. So then I looked at 10.2. The first sentence in 10.2 says the term political party, as herein used in this Article 10, shall mean any established political party. And I note that this language states that it applies to all of Article 10, and Section 10.4 is included, of course, within Article 10. My analysis is that the intent of the General Assembly was for a new party not to be considered to be an established party. Thus, when the General Assembly passed 10.2 and 10.4, its intent was that a new party should not fall within the concept of political party. According to 10.2, the new Progressive Party is not an established political party. Therefore, 10.4 does not require that any dual signers be declared invalid. And while I didn't think it was an issue, I continued to look at Section 7-10. It refers to activity. It refers to activity in party primaries, and it does not regulate signatures for new parties. Candidates for new parties do not appear in primary elections, only in general elections. And I looked at the third to the last paragraph in 7.10, and that sentence says, a qualified primary elector of a party may not sign petitions for the primary of more than one party. And to me, that means that 7.10 prohibits a voter from signing a nominating petition for a primary election of a second political party where the voter previously signed a nominating petition for a primary election of a different political party. But that's not the fact situation we have in this case. And here the individuals at issue first signed so the candidate could appear on the primary election, February 23rd, and then they signed for the new party so the candidate could appear on the ballot in the general election, April 6th. And the signers, in my opinion, were not signing two different petitions for the February 23 primary. Therefore, I find that 710 also is inapplicable. And so, in summary, my analysis is that the dual signers did not violate the quoted language in 10.4 or 10.3 or 7.10 because those sections do not apply to their actions in this particular case. So I would agree that with the other two members in their result to sustain the motion to dismiss and find in favor of the candidate.
Okay, so we have three decisions to sustain the motion to dismiss and find for the candidate.
So at this time, it would be appropriate for one of the board members to make a motion to sustain the motion to dismiss and to find in favor of the candidate and to order that the candidate's name be placed on the ballot.
So I will make that motion to sustain the motion to dismiss, find in favor of the candidate, in order that the candidate's name be placed on the April 6th ballot election.
I will second that motion.
Motion by Lavero, seconded by Avila. I vote aye. Alderman
Aye.
Avila? Mr. Cohen?
I vote aye.
3 ayes. Carried.
So now the next step will be, would the board like me to, the law requires that we have to do a written decision, basically recording, the deliberations and what the decision of the board is. So I think it would be appropriate at this time for the board to make a motion to direct me to draft a written decision, and then we will have to appear again together one more time to have the decision signed by the board members.
At that time, can we waive the appearance of others other than the board members?
If
So
they
we
would,
can just-
if they would so like to, would you like your appearance waived for when we do the decision?
Yeah, for Pericles Abassi, for the objector, I will accept the written decision served by email.
Okay, service by email?
And we, for the candidate, we will do the same.
Okay.
Thank you.
Okay.
So are the parties okay if we schedule the next meeting during the daytime then?
That's fine,
You
yes.
don't have to be here.
That's fine, Mr. Chairman.
Okay.
So I will make a motion to direct the board attorney to prepare the appropriate order for the decision and circulate it amongst the members at a subsequent meeting so that we can sign it, waiving the appearance of counsel and the candidate and the objector. All those in favor, I vote aye.
Aye.
Mr. Cohen?
Aye.
Okay, we have 3 ayes.
Uh,
I'm sorry.
Mayor, I have a question for you. I don't understand how to give my signature. Each of you two can watch each other sign, but you don't have a way of watching to see that the signature that I send is mine.
Actually, the board attorney's already worked that out, and she does have a way to handle that, so I'm sure she'll be discussing that with you.
Yes, Mr. Cohen, I'll be in
Sure.
touch. Essentially, we'll be putting you on a Zoom, and I will literally be holding the Zoom in front of on my computer in front of the Facebook Live. so
We'll
that
do the
people
rest by
can see it.
Facebook again, and then she'll have Mr. Cohen in by Zoom so we can see him sign. Okay?
Very
And
good.
do the parties
Mr.
agree,
Mayor,
have any?
stick with this lawyer.
Stick with this lawyer? Okay.
Oh, thank you.
No,
Do the parties have any objection to the signature, or to the signatures being affixed to the decision in the manner that I had just explained?
no objection.
No objection.
Okay, thank you. So then we will just need to decide on a date. So ballot certification is technically due on the 28th. If it's a day late, I'm sure our friends at the county clerk's office
The
will
ballot
forgive
certification
us.
is due for April on January 28th?
28th, yes.
They're doing it for the 28th and 29th for the February election.
Oh, really? Isn't it the 28th for April?
Yeah, I believe it is.
It
Yeah,
is the same date?
From other cases.
Wow.
I thought
okay.
ballot certification was a lot earlier for February.
No,
Yeah.
according to what I was told, they were going to have the ballots certified for the February election on the 28th.
I think that's the ballots finalized and printed. Or maybe I'm wrong. I
That's
don't know.
not what I was
Do
told.
you guys
but
know offhand?
You guys know better than I do, but that's what
Yeah.
I was told by the
Yeah.
Cook County Board Attorney.
Oh,
So
okay.
I don't know.
Okay, well, my understanding was that ballot certification is the 28th, so.
Okay,
I am a little booked up, but I could possibly do Tuesday or Thursday. I mean, Thursday is the day that we have to have have the ballot certified, so maybe we should do Tuesday. Or I could do Wednesday. I've got a hearing, a short hearing in the morning. I've got hearings up until about 2 or 3. Would we be able to do, say, 3 o'clock on Wednesday?
I'm available Wednesday at 3 o'clock.
Tuesday, we're gonna be.
I don't know whether I'm going to be a mandatory arbitrator in Waukegan or not. I guess I could just cancel it so I don't have it. But they start normally about 1:30, and usually they're done by that time. I suppose that if we pick a slightly later time, that there's no way that I would have a conflict there.
Would 3:30 work for everybody?
3:30
Say that
works.
again?
We do have council at 6 o'clock on Tuesday if you wanted to do it prior to that. I don't know what your schedule's for Tuesday.
Tuesday night, I have a meeting at 6:30, so yeah, I wouldn't be able to, and it's a big hearing.
That's fine, 3:30.
I've got
Right.
about 15 witnesses.
3:30 on Wednesday.
3:30 on Wednesday then.
3:30 on Wednesday?
Three-
Okay.
3:30 on
That's the
Wednesday.
27th. Yes, 3:30 is fine.
And we'll need you. That is the 27th, so,
And,
so
and I'm going to learn something about how to use Facebook to do this. So.
no, you're not going to need to use Facebook. You're going to use Zoom. I'll go through the process with you. I'll give you a call later tonight or
Okay.
tomorrow, and we'll go through the process. It'll be easy. It's not going to be much different than what we've done on other boards, so,
Okay.
or what you've done on other boards, and what we'll probably be doing on the boards that we sit on. Okay, so,
Well, gentlemen and lady, I'm sorry I was not there to see you in person, but I appreciate the hard work and the good work that each of you has done.
thank you.
Thank you.
and We
Thank you.
appreciate you.
So I just need a motion to adjourn then?
Well, we
Oh,
still,
you have
we
one
do
public
have one
comment.
public comment.
Excuse me, yes, go ahead.
So we do have one public comment. This was actually submitted the day after the last meeting, and the individual's name is Emily Kraiem, Kraiem, and she sent the comment in on January 14th at 10:19 a.m. So she states, "Good morning. I missed the opportunity to contribute a comment during last night's hearing regarding the challenge to Jose Ramirez's Alderman campaign signatures and was hoping that it is not too late to participate. I have resided in Berwyn's 2nd Ward since February 2015. My statement regarding the challenges to Mr. Ramirez's signatures is simple. As a resident, I would like to have a choice for alderman in my ward. I would like Mr. Roywood, the challenger, to have the opportunity to run on his merits and present his ideas and values to the residents of the 2nd Ward and allow me and my neighbors the opportunity to make a choice. The 2nd Ward deserves to have an alderman who is backed by a majority of the constituents and who represents the views of the city. The city council and the mayor also deserve an opportunity to serve with an alderman who was elected to his post by his ward, not one ushered in by default. The mayor and the council have important work ahead of them in the coming months, and it will be critical to their success to have the support of the community they serve. The only way to get that support is by allowing the residents of their wards to select or to elect the alderman who represents them. Sincerely, that's it. Sincerely, Emily Cremian."
Okay,
That's the only public comment that was received.
then I would move for a motion to
Recess.
recess until the signing.
Second.
So moved.
Motion by Cohen, seconded by Avila. I vote aye.
Aye.
Aye by Avila. Mr. Cohen?
Aye.
Motion carried. Thank you all.
Thank
Thank
you.
you, Mr.
Thank
Chairman.
Thank you.
I can never turn these things on.
Yeah, I mean, eventually there'll be a case that, you know, goes to court that, where this is the deciding issue, but it's, so far there hasn't been.
Honestly, be more explicit in the
Right, Alderman? Of the Broadview, I assume, yeah, and,